Welcome to our presentation on Challenging 280E, Understanding the Risks and Rewards of Amending Tax Returns. In this session, we'll take a comprehensive look at the current legal and regulatory landscape surrounding the cannabis industry, specifically how it applies to Section 280E of the Internal Revenue Code in states with their own cannabis regulatory frameworks. We'll explore various legislative actions, Supreme Court rulings, and recent federal agency announcements that have shaped the current environment and how these developments might be leveraged to build a case for no longer reducing deductions or amending tax returns to recapture lost deductions due to 280E. Additionally, we'll examine the actions of large cannabis companies challenging 280E and consider the potential risks and rewards of following in their footsteps. Finally, we'll discuss the steps you can take to protect your refunds. Over the years, a series of legislative actions and judicial rulings have laid the groundwork for the ongoing debate over cannabis regulation and whether it was the federal government's intent to allow state sovereignty over their cannabis regulations. One of the earliest and most influential steps was the issuance of the Cole Memo in 2013 by the Department of Justice. This memo instructed federal prosecutors to deprioritize enforcement against cannabis activities that were legal under state law. The Cole Memo marked a significant shift in federal policy as it acknowledged that states could regulate cannabis without federal interference. Building on the foundation laid by the Cole Memo, Congress passed the Rohrabacher-Farr Amendment, which further protected state legal medical marijuana programs from federal intervention. This amendment specifically prohibited the DOJ from using federal funds to prosecute individuals or businesses compliant with state medical marijuana laws. The Rohrabacher-Farr Amendment has been renewed multiple times and remains a key piece of legislation underscoring the growing recognition of state sovereignty in cannabis regulation. More recently, U.S. Representatives Earl Blumenauer and David Joyce have led efforts in Congress to expand protections for state legal cannabis activities, including adult use programs. They've introduced and supported bills such as Marijuana Opportunity and Reinvestment and Expungement Act, MORE Act, aimed at decriminalizing cannabis at the federal level and addressing social justice issues related to cannabis prohibition. These efforts reflect a continued trend toward respecting state autonomy in cannabis regulation and limiting federal interference in state legal markets. It's important to ask the question, if Congress intends to respect the state sovereignty, then why is it reasonable to penalize cannabis companies by imposing Section 280E? In August 2023, the Health and Human Services Agency made a significant announcement recommending that cannabis be rescheduled from Schedule 1 to Schedule 3 under the Controlled Substances Act. This recommendation was based on the recognition that cannabis likely has accepted medical uses and that its abuse potential is lower than other Schedule I substances like heroin and cocaine. The National Institute on Drug Abuse supported this recommendation, emphasizing the medical benefits of cannabis and its lower risk of abuse compared to drugs like alcohol and opioids. These developments highlight the argument that cannabis should never have been classified as a Schedule I substance, especially given that most states now have medical marijuana programs. Next, we'll review Supreme Court actions that provide a foundation for forming a reasonable basis to challenge 280E. The most notable case is Gonzalez v. Reich, decided in 2005, in which the Supreme Court upheld the federal government's authority to regulate cannabis under the Commerce Clause, even in states where it was legal. However, the dissenting opinions, particularly those of Justices Clarence Thomas and Sandra Day O'Connor, argued for a more limited federal role and emphasized state sovereignty. Justice Thomas, for example, expressed concern that the federal government's broad interpretation of the Commerce Clause allowed it to regulate nearly any activity, even non-commercial activities occurring entirely within a single state, thereby encroaching on state sovereignty. Since Gonzalez v. Reich, the composition of the Supreme Court has changed significantly. The current court is more conservative and more inclined to favor states' rights, as seen in the recent decision to overturn Roe v. Wade in Dobbs v. Jackson Women's Health Organization. Additionally, on June 28, 2024, the Supreme Court overturned the Chevron deference in Loper Bright Enterprises v. Raimondo, ruling that courts, not federal agencies, have the final authority to interpret ambiguous laws. This decision, along with others like United States v. Lopez and Murphy v. the NCAA, emphasizes state sovereignty and challenges federal overreach. If Gonzalez v. Reich were retried today, the outcome would likely be very different. There are also constitutional arguments against the application of Section 280E specifically to state legal cannabis businesses. One is that 280E violates the Fifth Amendment, which prohibits the government from taking private property for public use without just compensation. By denying standard business deductions, 280E effectively seizes a disproportionate amount of income from cannabis businesses, which could be viewed as an unlawful taking. Another argument is that 280E violates the 10th Amendment, which reserves powers not granted to the federal government to the states and the people. Rulings like Murphy versus NCAA emphasize state sovereignty, and similar reasoning could be used to challenge 280E on 10th Amendment grounds. These constitutional challenges have not gone unnoticed by industry leaders who are increasingly taking action to confront the IRS's enforcement of 280E. Several major multi-state operators have taken bold steps. Trulieve, for example, has reported receiving $113 million in refunds from amended tax returns for 2019, 2020, and 2021. Other MSOs, including Ascend Wellness, Curaleaf, and Cresco Labs, have announced their intentions to file their 2023 returns without applying 280E and amend their prior year returns, reflecting a broader industry pushback. While the potential rewards of challenging 280E through amended returns are significant, there are risks. Success could lead to substantial tax refunds, but there's also the possibility of audits and legal challenges from the IRS, as seen with Ascend Wellness, which was selected for an audit. It's crucial to ensure that businesses have a solid basis for their actions and are prepared for a potential audit process. Despite concerns raised by industry professionals about the risks of audits, including potential tax adjustments and penalties, history shows that penalties have been waived in cases like Olive versus Commissioner, Harborside versus Commissioner, and Beck versus Commissioner, when taxpayers relied on professional advice and demonstrated good faith and reasonable cause for their tax positions. We believe with good record keeping, a well thought out methodology, including our methodology using 471C, appropriate disclosures, and reliance on a competent professional, the risks of an audit can be mitigated. Additionally, businesses should consider statute of limitations when deciding whether to amend returns. Generally, the statute is 3 years from the date the return was filed or the tax was paid, whichever is later. For timely filed and paid 2020 returns, the window is closing soon. However, if returns were filed or paid late, the statute may still be open. If a business is hesitant to amend immediately, filing a protective claim for refund can be a prudent option. This preserves the right to amend in the future while ensuring potential refund opportunities are not lost. In conclusion, while there are compelling arguments for challenging 280E and amending tax returns, this decision should not be taken lightly. The lack of regulatory progress and the IRS's firm stance require businesses to proceed with caution. Working with professionals who understand these complexities is key to navigating this challenging environment. Thank you for joining us today. We hope this presentation has provided you with a clear understanding of the risks and rewards involving in challenging 280E. If you have any questions, please don't hesitate to reach out.